Nadell told responding officers Houston, Murray, and Sergeant Slarb that she was in fear for her life, so she jumped out of the vehicle while it was still moving. Nadell described the vehicle as moving 5 to 10 miles an hour when she jumped out. McKeon drove off, but returned minutes later and told Nadell, "Bitch, get back in the car right now." Nadell refused to get back in the vehicle, and McKeon drove off.
This case spirals out of control in seconds. What starts as a heated argument quickly turns dangerous. A woman leaps from a moving vehicle to escape, while the accused already carries a history of domestic violence. Now it's in the court's hands, and the judge must decide. Is this a one-time explosion or proof of a pattern that's gone too far?
Against Michael Anthony McKeon, 267066622. Detective, your name? He can have a seat at the table. Table. I'm sorry, John. Oh, he's got to go in there. Detective, your name?
Yes, sir. Detective Chad Jacoda with Flat Rock Police Department.
Raise your right hand, Detective. You solemnly swear affirm the penalties of perjury, the testimony you'll give in these proceedings will be the whole true self you've got.
I do.
Go ahead.
Okay. On 3/23/26 at approximately 8 p.m., suspect Michael Anthony McKeon and victim Jessica Lynn Nedbo were traveling west on Gibraltar Road from I-75 when they started to argue about McKeon's alcohol consumption. The argument became heated quickly, and McKeon punched Nadell in the left side of the face with a closed fist approximately 5 times. Nadell told responding officers Houston, Murray, and Sergeant Slarb that she was in fear for her life, so she jumped out of the vehicle while it was still moving. Nadell described the vehicle as moving 5 to 10 miles an hour when she jumped out. McKeon drove off, but returned minutes later and told Nadell, "Bitch, get back in the car right now." Nadell refused to get back in the vehicle, and McKeon drove off. Officers responded to the scene, as well as Flat Rock Fire Department, and Nadell was transported to Corwell Health Trenton for treatment for her injuries. Photographs of her injuries were taken at the scene. On 3/24/26 at 9:40 a.m., I, Detective Jacoda, spoke with Nadell via telephone. Nadell said that she did not remember all the events due to her intoxication level. She said she had consumed approximately a half pint of vodka prior to the incident. Nadell said she remembered arguing with McKeon and that she was punched in the face, but she could not remember how many times. Nadell said she could not remember exactly what the argument was about, but she did decide to jump out of the moving vehicle because that was the only thing she could think to do in the moment. She stated that she did sprain her ankle by jumping out of the vehicle. Nadell said she has been in a dating relationship with McKeon for the last 6.5 to 7 years. They currently reside together and do not have children in common. Nadell said she wishes for the relationship to be over and does not wish to pursue charges in this case. McKeon fled the scene after the assault. At approximately 10:58 p.m., Woodhaven PD was dispatched to an unwanted person complaint at a BP gas station located on West Road. Woodhaven made contact with McKeon and discovered he had an outstanding traffic warrant with Flat Rock Police and notified Flat Rock of such. Officer Murray was dispatched to the gas station and took custody of McKeon for his traffic warrant as well as the domestic violence offense. McKeon was transported to Flat Rock PD, where he was booked and lodged in a cell. McKeon's criminal history shows a litany of domestic violence convictions, including June 11th of 2012, where he pled guilty to a misdemeanor charge, and October 1st of 2018, where he pled no contest to a misdemeanor second offense domestic violence. I have no further information, sir.
Listen, I want to ask you a question. I thought you said on the date of the incident that he, and maybe I misunderstood, he punched her in the face at least 5 times, right?
Yes.
And were you told that, or was one of the officers told that by the victim?
Yes, they were told that.
And then later she's saying she was too intoxicated to remember.
Yes. She stated that she was struck. She just couldn't remember how many times the following morning when I spoke to her on the phone.
Based on your sworn testimony, I find the crime of domestic violence, third offense, which is a felony, was committed. There's probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint and warrant. Where were they living at?
According to the victim, they are currently homeless and living out of her vehicle at the time.
Okay. And he's already been fingerprinted, right?
Yes, sir.
Okay, I'm gonna authorize the issuance. You can bring him up. Come on up here, sir. So I find there's probable cause to believe the crime of domestic violence third offense was committed and probable cause to believe the crime was committed by the defendant. Your name?
Michael McKeon.
Michael Crawford, representing Mr. McKeon.
For purposes of arraignment,
I would like to stand and wait for more.
you have the right to remain silent, Mr. McKeon. Anything you say can be used against you in a court of law. You have the right not to say anything. You have the right to a lawyer today. You have the right to a lawyer at all subsequent court proceedings. You have the right to a lawyer if you choose to submit to questioning with law enforcement officials. Do you understand all that?
Yeah.
You have the right to a probable cause conference within 14 days. At the probable cause conference, your lawyer will discuss this case with the prosecutor at the preliminary exam. If it goes that far, they have to prove that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you'd be discharged. Do you understand that?
That's right.
Probable cause conference will be April 7th at 9 a.m. That's in front of Judge Hessen. She's on the state docket this until the end of April. Preliminary exam will be April 14th at 11 a.m. April 7th at 9, April 14th at 11. He wrote down an address on his request for a court-appointed lawyer as being on Caroline. Is that true? Do you live on Caroline?
Yes, with my parents. She is homeless. She used to stay with my parents. She don't anymore because of her children.
All right, listen.
Oh,
Stop.
okay.
Stop. Just stop.
I just.
Just stop. Okay.
What do you want to say?
Your Honor, despite how troubling these allegations may sound, my client is looking forward to returning to clear his name and vehemently proclaim his innocence, Your Honor. I don't think the court has to be concerned that he wouldn't return. He knows these are serious charges. He understands this is the third time he's being charged with something like this. But he states to the court that the court can count on him to return. He wants to resolve this.
When's the last time you worked?
Your Honor, it's been almost a year, Your Honor. My client's got significant health issues, and it's made it pretty difficult for him to work. He's got a seizure condition, and he also has blood clotting problems, Your Honor. And he's been wrestling with both of these conditions since he was diagnosed with them for about a decade now, Your Honor. So it makes it tough for him to find some work. So right now he's living off of unemployment, and his parents they're helping him out. But he is actively looking, Your Honor, and he's applying for SSD.
Did you find out what kind of injury she ended up sustaining? Detective?
She had contusions to her face. She had a sprained ankle, nothing that required any stay in the hospital. She was discharged the following morning.
What are you asking for?
No contact with the victim, obviously, and I would defer everything else to the court.
I'm going to give you the bond conditions first. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact with Jessica Nedball. You cannot write, phone, see, text, email, or communicate with her. You cannot have anybody else do any of those things for you or on your behalf. No contact with prosecution witnesses. You're not to purchase, possess or consume alcohol, marijuana, or illegal drugs. You're not to possess firearms. You're not to possess dangerous weapons. You're required to obtain a tether. You're not to be within 2 miles of the victim, her residence, or place of employment. I heard everything everybody said. You're not to be released until fitted with a GPS tether. 50,000, 10% is the best I'm going to do. You're going to have to post $5,000 to secure your release. That might be too low. April 7th will be your first court date. You are set. Good luck. Thank you.
Officer, have a seat back in that jury box real quick.
Thank you, Detective.
Thank you, Your Honor.
The judge makes it official. $500,000 bond, GPS monitoring, and strict no-contact orders. That's not leniency. It's the court taking control where the defendant couldn't. At some point, a person's past stops being a warning and starts making the decision for them. So what do you think? Did the judge get it right, or did the defendant finally push things too far? Comment below, hit like, and subscribe for more real courtroom breakdowns.